If you're using AI to create music, here's an interesting development. A German regional court today ruled in favor of GEMA, the German Performing Rights Organization, who had sued Suno on behalf of songwriters and composers they represent. I'm a professional producer and songwriting coach with decades of experience and a bachelor's in songwriting and production from Berklee College of Music. Suno argued that the court lacked jurisdiction, that its model learned musical patterns rather than storing files, and that training was covered under US fair use and EU text data mining exemptions. However, the court rejected Suno's fair use claims completely, finding cases that specifically proved Suno had memorized and reproduced protected works, including Alphaville's Forever Young, Lou Bega's Mambo No. 5, and Boney M's Daddy Cool. It ordered Suno to halt unauthorized reproductions, disclose revenues earned from the infringements, and pay damages. Now, what does this mean for music creators like us? It comes back to what I keep saying. Do not use AI services like Suno or Udio to write music for you, but only to produce demos and backing tracks. Always and without exception, write your own music yourself on your instrument, keyboard or guitar for the chord progression, or a clear melody that you sing if you don't play any harmonic instrument. Record a full demo of your entire song and upload that to the music creation engine. Don't just give a prompt to write it for you. Also, don't let these engines write the lyrics for you. A song is defined as lyrics plus melody. Chord progressions are technically not copyrightable, but I suggest, in light also of this lawsuit that Ed Sheeran was facing a few years ago, I suggest to make your demo as complete as possible to avoid any doubt that it's your creation. That demo, whether you register it first with a copyright office, which is ideal but costs money, or not, it is considered a tangible format, and in itself, as a tangible format, is already considered a legal copyright the second you created that demo. Copywriting it officially gives you additional legal protection. So it's good to do, but many of us are very, very productive and create a lot of songs, and it's just not kind of administratively possible to copyright every song right away. Now, if you upload that demo to something like Suno, then it will simply cover that song and create arrangement and interpretations based on the stylistic prompt you give, as well as the different slider settings you set. The less audio influence you set in Suno, for example, the more liberty it may generally take with a chord progression in my experience. But the lyric and melody will remain intact, and those are your copyright. Often people forget that there are two copyrights that are separate: the song copyright of the lyric and melody, and the arrangement, which is the master copyright. The GEMA case is about the former, the song, not the production or arrangement. If you have a paid plan with services like Suno, you technically have the right to use the production commercially. Though now many streaming portals have started flagging AI-created tracks, picking up on some kind of sonic fingerprint, without, however, knowing or stating clearly if the composition itself was created or co-created with AI. Right now, there's no way for them to know. Maybe that'll change in the future. But if you write the songs yourself, you're covered legally. Follow me for more insights, free tips and tricks about how to write better songs that land emotionally with listeners, and message me for personal coaching.